Labor law. How artificial intelligence in hiring process violates the Americans with Disabilities Act. Use of artificial intelligence in the workplace was the focus of the Equal Employment Opportunity Commission's recent guidance on the Americans with Disabilities Act and the use of software, algorithms, and artificial intelligence to assess job applicants and employees. The guide can help employers understand the requirements of ADA when using artificial intelligence in employment-related decisions, and it can also help applicants and employees understand how to address disability-related concerns when applying for jobs or promotions. Employers have implemented a variety of software programs in the hiring process, such as automated resume review software, hiring and workflow chatbot software, video interviewing software, analytics software, employee monitoring software, and employee management software. The ADA is a federal civil rights law that prohibits discrimination and requires reasonable accommodations for applicants and employees with disabilities. The federal law applies to employers with 15 or more employees, but the Virginia state law applies to those with more than 5 employees. People also read. The EEOC has a broad definition of disability, but generally it can include a physical or mental impairment. Even if an employer hires a third party to manage its algorithmic decision-making, the employer may be liable for a violation of the ADA if the software discriminates against an individual with a disability. While the ADA prohibits disability-related inquiries prior to an offer of employment, employers may notify applicants that reasonable accommodations can be made for them. For example, if a hiring process includes a video interview, the employer or software provider may notify applicants that the application process includes a video interview and allow them to request a reasonable accommodation. If an applicant requests a reasonable accommodation, the employer must respond promptly and make a reasonable accommodation unless doing so would cause significant inconvenience or expense. Mere inconvenience is not sufficient to demonstrate undue hardship. For example, some employers use knowledge testing software that tracks the passage of time, but an applicant may have limited mobility, making it difficult to use a keyboard. The EEOC stated, in this situation, the employer would need to provide an accessible version of the test, for example, one where the applicant can give his or her answers orally rather than manually, unless doing so would create an undue hardship. If it is not possible to make the test accessible, ADA requires the employer to consider an alternative test of the applicant's knowledge as a reasonable accommodation, unless doing so would create an undue hardship. All medical information collected in connection with the request for reasonable accommodation must be kept separate from the applicant's or employee's personnel file. Employers must also exercise caution with exclusion algorithms. An exclusion is unlawful if the person being excluded is able to perform the essential functions of the job with a reasonable accommodation. For example, employers may use a video chat box that analyzes applicants' speech patterns to draw conclusions about their ability to solve problems, but it is unlikely that an applicant will receive a fair evaluation if he or she has a speech disability that results in significant differences in speech patterns. The EEOC also warned against gamified tests, which use video games to measure skills, personality traits, and other qualities to evaluate applicants and employees. The EEOC said, if a company requires a 90% score on a gamified memory assessment, an applicant who is blind and therefore cannot play these particular games would not be able to achieve a 90% score on the assessment and would be rejected. However, the applicant might still have a very good memory and be perfectly capable of performing the essential functions of a job that requires a good memory. This is true even if the test has been validated. Employers working with vendors should inquire whether the tool was developed with people with disabilities in mind, including whether the tool might require disclosure of medical information, whether the interface is accessible, whether there are alternative formats, and what efforts the vendor has made to ensure that the algorithm does not disadvantage people with disabilities. In addition to screening, employers should consider disability-related issues during implementation. The EEOC proposes to clearly indicate that reasonable accommodations, including alternate formats and alternate tests, are available to individuals with disabilities, to provide clear instructions for requesting reasonable accommodations, and to provide all applicants and employees who are to be evaluated using the algorithmic decision-making tool be provided with as much information as possible about the instrument prior to the assessment, including information about what characteristics or attributes the instrument is intended to measure, the methods by which those characteristics or attributes will be measured, and, if applicable, the disabilities that could affect the assessment results or lead to exclusion. Employers should ensure that all parties involved in the process understand the ADA website and how to evaluate requests for reasonable accommodation.